Welcome to our preview of our 2025 DC Bar Changing Currents in Employment Law, the DC Bar's 3-hour fast-paced fall CLE that previews cutting-edge topics in employment law from both the management and employee side perspectives. I'm Scott Oswald, Faculty Chair of Changing Currents in Employment Law, and I'm joined by Chris Wilkinson, Senior Counsel at Perkins Coie. Chris, hello.
Hello, Scott. Great to see you.
Good to see you. Chris, you are speaking on a panel titled Loper Bright and its Effect on Employment Law. Introduce us to your co-panelists and some of the key things that attendees at this year's Changing Currents in Employment Law can expect to learn from your panel.
Yeah, so I'm glad to be joined on this panel by Dan Kohrman, who's at Gilbert Employment Law. He spent some time at the Department of Justice, so knows these issues very well. He's a strong litigator and appellate attorney in private practice, so I'm very glad to be joined by Dan.
So, Chris, what is some of the advice that you're giving to your clients about what deference they should give to agency rulemaking in the aftermath of Loper Bright?
Yeah, so I think the first thing that clients need to understand is the world sort of before Loper Bright, which was the world of Chevron. And certainly the world of Chevron was where courts accorded deference to agency rulemaking. And therefore, what an agency said in their rulemaking would be certainly what you would often see in the final rule. Now, in this world of Loper Bright, what we're starting to see and what I've been advising clients is to be looking for this patchwork, a patchwork of individual judges now being able to determine what is the best reading of a statute, and to understand that depending on your jurisdiction, if you're in, for example, the Northern District of California versus the Eastern District of Texas, judges may be looking differently at the same statute. You need to be aware of that patchwork and how to navigate it, especially in your compliance efforts.
So for a risk-averse client who's maybe taking a position in a jurisdiction where a judge has not yet ruled, Chris, what kind of advice are you giving to that risk-averse client?
For a risk-averse client, I think the most important thing would be to take a conservative approach. And by a conservative approach, what I mean is that you would want to look at the statute yourself and determine, is there any way that a judge can interpret this statute that is different than the way that an agency has interpreted a statute? In that instance, what you want to do is sort of move slowly and then determine if there's going to be litigation, because sometimes there's not litigation over rulemaking. But if there is litigation, and often this litigation is filed very, very quickly, you want to think about getting your compliance efforts in place, mainly because, and we'll touch on this a little bit, it used to be that judges could issue nationwide injunctions and you would be very fine across the transom. But now with a more recent Supreme Court case, it now is going to exacerbate the idea that this patchwork will continue to exist. So again, thinking about the jurisdiction you're in, thinking about how you move slowly in your compliance efforts, and be ready to comply because, again, a judge in one jurisdiction may look differently at a rule than in another jurisdiction.
Chris, thank you. I look forward to this panel in October. And to our audience, I look forward to seeing each of you on Tuesday, October 28th, 5:30 p.m. with our reception for our in-person attendees. You can register right now using the CLE tab at dcbar.org.